come before us this morning is State of Ohio versus William M. Knight. Both sides will have 15 minutes to present oral argument. If you're the appellant and wish to reserve any time for rebuttal, let me know when you get started. I'm keeping this clock as well as you can see it, if I operate it correctly, you can see it on the wall over there. Please don't use the names of any victims or minors as we are recording this oral argument. It will be posted on the court's YouTube channel. Pete, right the race, you're ready to see who you are. Good morning, Mr. Leslie.
Good morning, Your Honors.
Would you like to reserve any time for rebuttal?
Yes, Your Honor, I would like to reserve 5 minutes.
Okay.
Your Honors, if it please the court, my name's Mark Ludwig. I'm presently appearing pro bono as I have since my original appointment for the delayed appeal. That was a retained matter through the court, but this court's familiar with the background record facts because it's twice recited record facts. Mr. Knight's post-relief conviction petition addresses matters not in the record, but the state's arguments don't address any of his allegations. The PCR was dismissed based solely on a finding that it was untimely. Now, with all due respect, the question is not whether an appeal taken from a post-conviction relief that followed on a reopened appeal. That's not the issue. And this court's free to tell me, hey, you read that wrong. But what this court said when it reopened the appeal was, quote, this case shall proceed as an initial appeal. Period, the end, no more. Now, if Mr. Knight was wrong in taking the word, and I was, apparently because the trial court agreed with the state, taking the word initial to mean only the, you can only appeal from the, if it's the first direct appeal, right? Well, that's not what this court said. And when the court said you can appeal, reopened it, it said you can proceed as an initial appeal, and the state never objected that that was an initial appeal.
Well, counsel, our forms obviously are just standard forms, and isn't that really a document that is used to inform the attorneys how to proceed with the filing of briefs and the time limits?
Your Honor, if I could fudge all of your words in your orders as articulately at that, I probably wouldn't be here. But no, I don't think it's just a direction to me as to how to proceed. I think the word initial meant initial. And I suspect if that was foreign language, maybe it'll change based on this decision, which is, oops, we won't use that. Or we will remind somebody that a delayed appeal you can't do a PCR from. But there's no doubt that if initial meant initial, any initial appeal proceeds, the PCR proceeds from the filing of the transcript in the initial appeal. And there's no dispute here that his PCR, pro se PCR, was filed within 1 year of the filing of the transcript in the, if you will, new initial appeal. That's what we're arguing about. And again, I'm sorry if I'm trying to hoist the court on its own petard of the word initial. But if nothing's been beat in my head over the last 48 years of doing this, is that when the court says something, it generally means what it says. And I don't see there's anything unclear about the word initial.
Well, isn't that language right, just straight from the rule, though?
leave the word initials there. I'll have to, once again, you're ahead of me on reading the rules, Your Honor, but I'll have to relook at that. And then, you know, when Mr. Knight appeals and says, gee, I didn't know that my petition had to be filed at that, within that time frame, because Jeff never told me. Well, we're told, well, that wasn't what you complained about in the PCR proceedings. So you can't raise that on appeal. We go around and around and around. And there are 8 issues outside the record that he tried to raise and tried to have somebody consider. And I think more than one of them has some merit. I started in this 48 years ago wanting to be so proud of what I was doing. And I want the record clear without mentioning the victim's name. I am very sorry, and I know Mr. Knight is. I'm very sorry. Nothing we say, no time he serves, no matter what happens, will bring that life back. And he's known that. But in this time, for empathy's sake, not for sympathy's sake, in this time, he'll be 85 before he's out under this sentence. In this time, he's lost his sister and his daughter, who was a witness to these events. They have both passed. From empathy standpoint alone, he has suffered some. No suffering like the victim did. The victim is deceased. Believe me, the person who most strongly wishes that was not true is Bill Knight. Your Honors, you know, there's the argument, they say there's the argument prepare for and the one that you give and the one, oh, you should have given. Those are the 3, but it's no one, I think, worth half their salt, you've seen the facts of the record facts of this case, would believe that if we were trying this case today, where self-defense is the burden that the state must negate, this whole case might have turned out differently. Now, there's yet to come the question of, should that self-defense have been applied by this court in its 2 decisions? And because the statute was in effect when this court was deciding those cases. It was not in effect at the time, but that's a whole other argument. All I'm trying to get across is the old expression that Lady Justice is blindfolded is very, very true. But in this case, I believe it's because she can't stand to look at what's happened. I'll reserve the rest of my time if I may.
Thank you, counsel. We'll have 5 minutes for a while.
Good morning, Your Honors, and may it please the Court. I'm Jacqueline Court on behalf of the State of Ohio, which is the appellee. There really is one umbrella question in this case, and that is, did the trial court actually have jurisdiction to consider Mr. Knight's substantive claims in his post-conviction relief petition? The umbrella answer to that is no, because it was untimely. Now, does it really matter that reopening, that the order issued by this court when it allowed him to reopen his appeal said the case was to proceed, quote, as an initial appeal? No, the state submits it does not. There are a few reasons for that. And Judge Carr, you had asked whether that language that was in the court's standard form, isn't that straight from Rule 26, and it is. The App Rule 26B7 says, and I quote, if the application for reopening is granted the case shall proceed as on an initial appeal in accordance with these rules, except that the court may limit its review to those assignments of error and arguments not previously considered. So that language does come straight from the rule. And one thing I would remind the court about to illustrate why a reopened appeal is not a direct appeal, which is what the Supreme Court of Ohio has found in Morgan versus Eads and other district courts, including in Hudson from the 2nd District, Moses from the 5th District that were cited in the briefs, and the Supreme Court's summary decision overturning Fuller from the 10th District, and lately, which was in the Notice of Supplemental Authority, Graham from the 11th District, is a reopened appeal, again, is not akin to a direct appeal. And just looking to the rule, you can see that the structure of a reopened appeal is somewhat different from an initial appeal. For instance, in App Rule 26B8, the rule actually allows for something that's not permitted at all in an initial appeal. And that's an evidentiary hearing, one that can take place before a magistrate. No such procedure is permitted in a direct appeal, so or in the initial appeal.
But counsel, wouldn't that be just for determining whether or not the appeal will be reopened?
It's not really clear from the language.
What other purpose would be, because you can't add to the record.
That's correct. So even though it's not terribly clear from the rule, but it still is an additional procedure that's not available in the initial appeal. And when we're talking about the initial appeal in accordance with the rules of appellate procedure, that applies to the briefing schedule and how it will proceed before the Court of Appeals. It doesn't say that it restarts the post-conviction relief clock. And one must be reminded that post-conviction relief in Ohio is purely a creature of statute. So there is no constitutional right to that, and what this court does in its procedures does not have any bearing under the statutes on what happens in post-conviction relief. But again, I would refer the court to the Supreme Court's authority in Morgan versus Eads, which held that a reopened appeal operates as a collateral attack on the original appeal. It does not vacate this court's original judgment in the initial appeal. And so it is not part of the original appeal.
Let me ask you this, in this particular case, was a new transcript order, was there anything new that was presented in this appeal that wasn't presented in the old appeal from the record?
No.
Okay, I asked you probably two questions. Was a new transcript ordered?
No new transcript was ordered and nothing new was added to the record when the appeal was reopened.
So it was just a matter of just reviewing whatever is in the record to begin with?
That's correct.
So there was no new notice of the filing of the record?
There was a new certification, but there was no new substantive material that was included in the record or supplementing the record. Now, does it matter that Mr. Knight filed his post-conviction relief petition pro se? And the answer to that is no, and that's because even though pro se litigants are held to less stringent pleading standards as represented parties, they are still nevertheless held to the same responsibility to follow the rules of court and to follow the statutes, and that includes the timelines in Ohio's post-conviction relief statutes, which was an issue that, contrary to the reply brief in this case, the state did raise in its initial response to Mr. Knight's post-conviction relief petition before the trial court.
Counsel, I guess one of the concerns I have in regard to this, I appreciate the fact that you say this is statutory procedure, and I'm well aware of that, but at the same rate, the court every day interprets statutes. And I guess one of my concerns in this is if we have a procedure set in place to reopen an appeal based on ineffective assistance of appellate counsel, that could very definitely impact what would be raised or not raised in regard to a post-conviction relief action. I'm not saying in this case, I'm just saying in general, depending on the facts of each particular case.
Well, not necessarily, because the way the structure we have is that a person's post-conviction relief petition can proceed before the trial court at the same time that their direct appeal goes forward. So even though some trial courts will delay issuing a ruling on a post-conviction relief petition until after this court resolves the direct appeal, technically they can go forward at the same time because the bases are different. So, this court is limited to the record that was created at the trial. Post-conviction has to go forward on a record that is outside, or on facts that's outside the record that's developed for the appeal for this court. So that's why they are on parallel tracks, essentially. So, and it would be difficult, and I acknowledge it would be difficult for a post-conviction relief petitioner to say in a PCR petition that they have already suffered from ineffective assistance of appellate counsel, not knowing at that stage how appellate counsel may necessarily have performed in the direct appeal. And I hope that gets to starts to answer your question.
No, I know what your response is. I know where you're coming from. I'm just thinking in my head. Thank you.
Oh, you're welcome. Now, also, I wanted to touch on very briefly, does it matter that Mr. Knight's pro se brief states that, or actually I should rephrase that. It doesn't really matter whether or how Mr. Knight was advised of the PCR deadlines in this case. Unfortunately, the statute 2953-23 does not include an exception to the post-conviction relief petition deadlines for misadvisement or non-advisement by counsel. And it's well settled that trial courts, when they are considering whether they have jurisdiction to consider a post-conviction petition, cannot excuse an untimely petition for any reason that's not included in 2953-23. And that's from this court's authority in the Baskerville case, which was cited in the brief. Again, though, post-conviction, or the pro se litigants are still responsible to follow the rules of court, to follow the statutes, to meet the deadlines that are included in the rules and statutes. So you have to look at what the trial court had before it, and it had to first determine whether it had jurisdiction to consider any of the substantive claims by Mr. Knight. And finally, just briefly, when Mr. Knight is asking essentially for relief for empathy's sake, the state of Ohio may empathize with Mr. Knight's situation, being a senior citizen in prison, and with all parties in this case. Obviously we have the family of a victim who is deceased and sympathizes with the hardship and tragedy of this entire case. But the trial court in this case was not empowered to release Mr. Knight or grant him post-conviction relief based upon empathy or sympathy, and neither, unfortunately, is this court. So those are not issues that this court can properly address. So with that, unless the court has any other questions, the state would rest on the briefs and urge this court to affirm.
Seeing nothing, thank you, counsel.
Thank you.
Takes a minute. Okay.
I understand.
In In terms, if it please the court, in terms of the deference to be given to pro se litigants, I'm going to stand with Haynes versus Kerner, the Supreme Court of the United States. I think it sets the standards for that. Now, we can cite, and it's cited in our brief, we can cite all the other cases since then that, in effect, I believe, water down the importance of how one treats a pro se person. But I don't think the Supreme Court, as often as it may be less than clear, I don't think it's unclear in Haynes versus Kerner about how we treat pro se litigants. First of all, I don't want to practice anymore when empathy is not part of what this court does. I didn't suggest for a second that because of empathy, you should do something. But when this court loses empathy, it's time for me to go out to pasture. Do you not see what the state does in nearly every post-conviction case? We don't talk about the issues that are trying to be raised, the facts that are outside of the record that might make a difference. We do what every good magician does, which is, no, look over here. Over here, because we don't want to look at these 8 things you raised. Look over here where he didn't dot this I or cross this T correctly. He didn't do something right. And look at the wealth of authority we have, where we have run over pro se litigants. That's what most, in fact, I think we emphasized in our reply brief, that most of the cases about, doesn't apply to a direct appeal, about that indirect, most of those cases that they cite are pro se cases built on the bedrock of running over a pro se litigant who didn't have counsel.
Mr. Ludwig, I have a question for you, and you're actually the perfect person for me to ask this question. Is there a duty on defense counsel to advise his or her client about post-conviction?
Most definitely, Your Honor.
Okay, and where does that duty come from?
I think one of the cases we cited is McGinnis.
You're referring to your brief?
Yeah.
Okay.
Yeah.
I know what you're talking about. Right.
I think we tried to talk about that. When you're appointed for an appeal, or retained for an appeal, one of the first things you should generate with the notice is notice to the client that says, by the way, no matter what happens in this case, you have 1 year from this date. It used to be 180. In fact, some of the cases they cite are 180-day cases. It's your obligation to tell them that. Look, I've been retained for a personal injury case. It's my obligation to tell you, we got to file this 1 year from the date of the crash. There's no doubt that those basic things. Now, again, once the client's on notice that that's important, we can do our Pontius Pilate and wash our hands of that duty. We told him it's for him to do. I guess it's the magic of don't look at what the person complains of. Look over here at this and decide it based on that. It's not timely, so you don't need to bother yourself with what may be outside the record, and it's not your bother. It's simply, I think, appropriate for you to say in this case, the trial court should have considered whether this was part of an initial appeal meant it was timely, or the trial court should have considered is this an untimely petition? Instead, he gets hoisted again by this. She decides it's untimely because someone filed a poor reply brief there saying, gee, I think it's timely. And then the trial judge decides, no, it's not timely. And he complains, well, gee, I didn't know about timing the first timing.
Speaking of timing, counsel.
That's it.
Regretfully, I need to
Oh,
let you know.
Did I do that smooth? Was that a good transition?
Thanks for
Thank you.
throwing me that softball. Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision, which we mail to all parties to this appeal on the day it is issued, as well as posted on the Ohio Supreme Court website. Thank you both.